Did you know that some people make the mistake of hiring the wrong lawyer, just as they make the mistake of going pro se? Because either one of them could be the wrong decision for you. How about if you put the two together, though? That's what I call a hybrid. That's what I'm talking about today. Stay tuned.
Welcome to Self-Represented in Family Court, the only podcast you need if you're feeling lost, stuck, or overwhelmed in family court. At Self-Represented, we don't waste time discussing the law like all the other podcasts. We focus on what really matters in your divorce or custody case. That's strategy. With your host, Tracey Bee, former family law attorney turned pro se family court strategist.
So, the last episode, I discussed going from pro se to lawyer represented and going from lawyer represented to pro se, and some things that you should really take into consideration when you're in either of those positions. But what I wanted to expound on today was circumstances where you do kind of like both. It's like a hybrid situation. Some parts of your case you might self-represent, other parts you might have a lawyer work with you in some capacity. It's not fully lawyer representation, but it's lawyer involved, lawyer, guidance, lawyer support. Some qualified professional giving you some legal advice along the way, but they're not fully representing you in your case from filing to finding. So that situation is happening more and more these days because nowadays a lot of jurisdictions are allowing lawyers to do what's called limited scope work or consulting work or shadow work, whatever the technical term is called. They're allowing lawyers to be a little bit more creative in how they can provide assistance with for clients like you who are self-representing. And so the reality is that even though it's becoming more widespread, sometimes it's still not the best scenario for you. And it's not necessarily not the best scenario. Sometimes it's just not used appropriately or correctly or strategically, because everything in family court is about strategy. So hybrid sounds like you're maintaining control, and you are, because you're still self-representing. You're just working with an attorney who is sort of shadowing you, is sort of like consulting, sort of in the background, but they're like really guiding you by giving you legal advice when you need it. They're just not showing up to court for you or to depositions or mediations or anything on a consistent basis. They didn't file an actual notice of appearance in your case unless it's required that they file what's called a limited scope or a limited representation notice for the court, just to let the court know that you are working with a qualified professional. So some people use the hybrid situations mainly because it saves money, but a lot of people are using it nowadays mainly because it helps them not fumble their cases. Being pro se is not easy. It's not for the faint at heart. It's not for the thin-skinned. It's not for the ones who are overwhelmed just with the emotional or the mental aspects of their case. Some people are just overwhelmed with other things going on in life, and so it's kind of impossible for them to self-represent. I understand some people don't have a choice no matter what they have going on in life, but for the ones who are choosing to self-represent or who are been thrown into the pot and have been doing okay, sometimes they may choose to have someone guide them along the way so that they have a little bit more freedom, a little bit more legway to not overwhelm themselves or not spend all their extra time just doing research and legwork and all that stuff. So, some people do it because it helps them save money. It is, it can be less expensive than actually having a lawyer fully represent you. And so that's another way, that's another reason. But some people do it for pure strategy. Yes, some people use that hybrid scenario where a lawyer may, review documents, or sometimes they even draft documents, may show up to some appearances, like when there's a hearing or oral arguments on motion, or may show up at depositions, or may show up at a mediation or settlement conference. They may show up for some things that you actually hire them to show up for. So that they may actually, send a letter on your behalf, or, things like that. So they're not fully representing you, but they may, handle some aspects of your case. And so some people actually do that for strategy purposes. And when you're doing it for strategy purposes and you know what you're doing and you set it up that way, then you have a better chance of, actually succeeding. But if you do the hybrid and you don't have a strategy, you just, winging it, that's not necessarily the best approach. Even though you do have this qualified professional guiding you and consulting you and coaching you, sometimes the piecemeal aspects of it is just not the best, route for you. The discontinuity or the lack of continuity can create a problem for you, more of a problem. So let's talk about what people think hybrid is. Most people think hybrid is like, hey, I'll just do what I can on my own, and then I'll use a lawyer whenever I need help. And so that means, they're going to use a lawyer to pretty much confirm things or perfect things or advocate stronger or have a more cohesive approach. Some people, use lawyers just for the reputation or the relationship they have with the judge, with the court staff, with the opposing counsel, several things. So let's get into what hybrid actually is. Hybrid representation from my perspective. Hybrid representation is you are, from the court's view, self-representing, right? There's no lawyer of record on your case. There's no lawyer who the court can reach out to and contact. There's no lawyer that opposing counsel could reach out to or contact other key players, the opposing party. There's no one specific that any key player in your case can reach out to on your behalf that is standing in the shoes of your representation, your advocate. And so you actually are self-representing. That means the court sees you as self-representing, pro se. The key players see you as pro se. The opposing counsel, opposing party, everyone sees you at pro se. The hybrid part comes in where you might have a lawyer shadowing you. That means the judge is not aware that somebody's guiding you or supporting you or assisting you. The opposing counsel may not even be aware of that. Even the opposing party, no one may be aware of that. The only time they might be made aware of that is if the rules in your jurisdiction requires that. There's some jurisdictions that require that you put the court on notice or you inform the court that there is somebody who's providing, coaching, consultation, legal guidance to you, but they're just not officially on the record as your attorney. And then sometimes they may know that just because, the products or the work that they produce and that you submit on your behalf, it's just clear that it's, was created by a qualified legal professional. And again, sometimes in some places that's okay, but you really need to understand the rules. You need to know the rules. And, when you find an attorney who's willing to do that, they're going to know the rules and they're more than likely going to follow the rules, hopefully. So that's what hybrid is. Hybrid is, from the court's perspective, you're still self-representing, but you might have an attorney help you out here or there. You may even have an attorney show up to court for you for a specific court appearance or hearing, as I mentioned before. And so that's what hybrid is. The thing where people mess up with hybrid is that they don't, as I mentioned a few minutes ago, don't have a strategy behind it. They don't have any solid game plan about using someone like a limited scope or a legal advocate or a legal coach or something like that. And so you should definitely create one before you decide to, to use one, because sometimes you may not even know, that may not even be your intention to use somebody. You may get to the point where you don't have a choice, because there's a part of your case that is really challenging, or it's really complicated, or it's really above your ability, your capability. And so you feel like you have a better shot at, accomplishing your goals for your case if you have someone who's experienced and qualified to help you out. And there's nothing wrong with that. In fact, I suggest people, if nothing else, have an attorney on deck that they can actually get a consultation from here or there when they're pro se. I'm a big advocate of that. If you're pro se and you're 100% pro se, it's okay to have a lawyer or a couple of lawyers, but ideally one lawyer that you can go to and just get some sort of, guidance from here and there every now and again. No representation, just pure legal advice. And so that's part of being strategic, is, having somebody in the shadows just guiding you. You have a strategy, you created a game plan, and you factor them into your game plan. So let's talk about what hybrid looks like when it fails, because it does fail quite often. So scenario number 1, you draft the motion and you file it yourself. But then it's time for the hearing. You have to do a hearing on the motion because you requested oral arguments, or you're in a place with oral arguments or an automatic, and you don't feel comfortable actually speaking in court on your motion. You're confident about the motion that you created, that you drafted, that you submitted, that you filed, but you're not that confident about actually speaking in court regarding the contents of the motion. So you hire a lawyer for that. This is a limited scope lawyer that's going to show up to the hearing. It's going to prepare by reviewing the things necessary for the hearing. And they're going to show up to the hearing and let the judge know that they're only there for... Now, every jurisdiction does not allow lawyers to do this, but so you'd have to find out if yours is one of them that does or does not before you actually venture into doing that. But in the event that you are, sometimes it's a great idea, because those hearings, when you go to those hearings pro se, and you have to remember to argue what's in your motion, and you have to remember the rules, and you have to make a strong legal argument, and you have to understand the process, it can be overwhelming. It's one thing to write a really kick-ass motion. It's another thing to go and advocate and speak for yourself on that motion and the contents of that motion in open court, because the rules are going to apply. The court has decorum. The court has its own way of doing things. There's a process, not to mention you're basically performing in front of, a room full of people, maybe not a room full of people, but a room with people in it that are listening, that are watching you. And sometimes you can get anxiety just thinking about it, or let alone doing it. And then that can really interfere with the merits of your motion. You could have, like I said, a kick-ass motion, but you can actually basically destroy its effectiveness by going in to advocate for yourself for that motion, on that motion. So in some instances, it might be a great idea to get a limited scope attorney to do the hearing for you, the oral argument for you in that particular scenario. So the lawyer reviews it, and the lawyer might say, hey, this isn't how I would have framed this. This motion is not necessarily the best legal argument. And so what should the lawyer do? Should the lawyer move forward and make the argument as best they can based on your motion? Or should they go ahead and amend the motion if they can? Because there are rules about amending motions. You have a specified time to do that. And, the rules are going to apply. So should the lawyer actually go ahead and amend the motion before they go in to argue for you, or, not? Or should they just turn it down completely? So that's a big problem. That's a big issue, right? Sometimes that's where the disconnect is. How about this one? Scenario number 2. You handle all the communication and all the strategy, and the lawyer just does the filings. But, you're not aligned. You're not working together as a team. You're not really that in sync, because your tone, your priorities, your long-term goals are going to take precedence for you. They're going to be the top of the list for you. They're going to be the underlying motivation behind most things you do. So now this lawyer is doing the filings. There's no other involvement. The lawyer has no other involvement with your case. They don't meet with you regularly. They don't communicate with you regularly. They just are doing limited scope. They're just doing this, this one-off task or these one-off tasks. So now the filings don't match your narrative, right? Because the lawyer is just, creating filings based on the limited time, the limited availability, the limited access to information, the limited communication with you. They're doing these filings based on what they know. And so now your priorities that we just discussed are not incorporated into those filings. That's not necessarily a good thing. How about this? Scenario number 3. You use different lawyers for different tasks. Now, I am not a fan of that at all. There's too much discombobulation going on there, right? Use one for motions, one for that will coach you or advise you, and then, when trial comes, you want to hire a different one for trial. It might work, but I can tell you right now, the judge is not going to be too thrilled with that at all. And a lot of what you need to consider, especially as pro se, is the impression that you're making before the court. That is huge. The impression lawyers make before the court is big. So it's even grander for you. It's even more of a big issue, a big concern, a big thought factor that you need to weigh. You need to absolutely give that some consideration. And so anytime you're doing something and the judge is not a fan of, or the judge has, their own problems or issues with it, you might want to think of another way. And even it could be unfair, unreasonable, biased, whatever you want to call it and frame it as. At the end of the day, the judge is going to be the one making decisions, making rulings, issuing court orders in your case. And so, especially as pro se, you don't want to do anything that's going to encourage them or persuade them to issue rulings or court orders that are not favorable to you. And so having different lawyers coming in and out of their courtroom on different aspects of your case is not necessarily the best idea. Because what the court is going to see is, you're just all over the place. They're going to take it as an affront to your view on the whole process. And they're going to think you're not taking it seriously. They're going to just, basically, issue rulings and proceed and handle the case as if you don't care what the outcome is. You have no interest in the outcome either way. And that's definitely not true. We know that's not true. So you have to have a strategy. Let's talk about why hybrid fails. The real reasons why they fail. Again, you have to have a strategy. You think the lawyer is going to guide things. They're not. They're just going to show up for what you pay them for, and that's it. You have to have a strategy. And a strategy is, coming up with a game plan. It's literally going through every aspect of your case, the good, the bad, and the ugly. It's taking a look at where you are, what's happened. It's taking a look at what you want to happen. It's taking a look at who the other party is, who the opposing counsel is, who the judge is, what's against you, what's for you. And it's taking all of that information, every single piece of it, including your personal situation, your financial, your mental and emotional. Nothing should be left out. Your strategy should include a complete examination of every layer of every aspect of your case and deciding what to do as a result of all of that. Nothing's going to be written in stone. Nothing's going to be intransigent, but you still need to have a solid plan to start off with, because being all over the place is definitely not the thing to do in family court. It's already discombobulated. It's already fractured and dysfunctional. Now you're going to go in with this, the same mindset with the same presentation. It's not going to work. It's just not going to work. You have to get a strategy intact, including when it, using hybrid situations, using legal professionals. Another reason is your execution is out of sync. Your timing is off. Your arguments don't build on each other. Again, everything in family court is contextual. It's not a one-off. They're not isolated. Everything feeds off of or builds off of the other things. Every single thing. Even if you were in court years ago and you're in court now in what's called a post-judgment or a modification, what's happened in court in the past is going to have a play in what happens in court now. It may not have the same impact as if it were the same case, the same continuous open case, but it is going to have an impact. What happened in your case 3 years ago, who the judge was, why the judge ruled the way they did, the circumstances that existed, those are going to matter now. So making decisions in a vacuum, out of context, like using lawyer here or there and no continuity or no key timing or no context is not a good thing. It can really cause more harm than good. Another thing, the third reason is that, there are narrative breaks. This is the biggest one, actually. Your case is a story. Your case is a narrative that it's your responsibility to go in and tell that story and frame it in a way that the judge is inclined to listen to it. And not just listen, but to believe it and to rule on it based on logic. And so how can you do that when you're having piecemeal lawyers come in and they're just making piecemeal arguments? They're just doing piecemeal things. There's no continuity in your story. There's no cohesiveness in your story. So those are the, major things I can come up with. I'm sure there's more, but I will talk about those if you need to. If you book a strategy session, we can talk about some of those things. If that's what you're doing, that's what you're considering doing, and you want me to take a look at it, or you want to bounce some ideas off on me, or you want to, work out a strategy that's going to best suit you and your goals, feel free to set up a strategy session, a 1-hour strategy session, and we can do that. I've done it. I've helped people, find the legal professionals that they want to use in hybrid situations. Yeah, I did. Because I know quite a few of them. I know quite a few lawyers who are coaches now. I know quite a few states where they allow lawyers to do limited scope. I know people who have successfully worked with limited scope or, have been in hybrid situations and they've done it successfully. So I can definitely help you. So what it should look like. Your core principle should be that you control the strategy. Your lawyer or the lawyer that you're using in a hybrid situation is just basically going to focus on execution. That's it. Try to limit how much control you give them. Try to maintain some sort of continuity in the best way you can. Try to ensure that they don't derail from your narrative, from your story, from your goals too much. Try to ensure that they are a cohesive part of your strategy, your overall game plan. How do you do that? Well, instead of just asking them to draft or file documents for you, you might want to add an hour to do a consultation with them and discuss the background of your case so they can give you some legal advice. And then they're more prepared, they're more apt to do those limited scope tasks, more in a more cohesive way, in a more continuous. There's more continuity. There's not the narrative breaks as much because you've actually spent some time talking to them. Because I'm going to tell you, if I do limited scope, I'm not talking to you for an hour and drafting your documents unless I'm charging you for both. I know it sounds crappy, but that's just the way it goes. Time is money. And, expecting someone to give you an hour conversation when you're paying them to draft the document is just not the smartest thing. Lawyers get paid by the hour. Our time is money. And, even limited scope, especially limited scope, as a matter of fact. So, the hybrid sweet spot. Hybrid works when it looks like you understand your case deeply, you understand the ins and outs, you understand the challenges, you understand the judge, you understand the process, you understand the rules, you understand it That way you can communicate it effectively to the hybrid lawyer. You can communicate efficiently, articulately, and you can pretty much ensure that they understand exactly what's going on, exactly what you want from them, exactly what they're expected to do. There's no room for miscommunication or misunderstanding. And you're actually directing them. You know exactly, how to direct them. You know exactly what the control you're giving up to them, and you know what you're maintaining. You know that every move has a purpose. You're not doing things just ad hoc, flying by the seat of your pants. You're not allowing them to do that. You're not allowing them to, make decisions that are out of context, that are just not part of your overall strategy. And this way, every, professional you use, they're aligned. They're aligned with your mission, your goal, your story, your narrative, and they don't stray too much. They don't show up to court making you look like you're all over the place. They make sure that you make sure that they are part of your plan, part of your theme, part of your theory, part of your case, not necessarily in a representation advocate kind of way, but they're part of it because they understand exactly every element, every component of your case that that you've expressed to them, that you shared with them. So if you are thinking about a hybrid situation, again, feel free to let me know. We can talk about it. But if you are, I suggest you start off with coming up with a game plan, creating a solid game plan. If you want to know how to do a game plan, feel free to email me. I believe I created a template. I haven't used it in a while, but I created a tool that will help you create a strategy that I used to give out when I first started, doing pro se strategy work. And so I'm sure I still have it in my library somewhere and I can pull it out. And I may just tweak it actually. If you reach out to me, if you email me at support@thedivorcesolutions.com. Or you can email me directly at divorcecoachesq@gmail.com. But so, yeah, if you're thinking about doing a hybrid situation, it may be a good idea. It might be. Also, if you can find out what your judge's position is on that, or, what the bar's position is on that, that would help too. It certainly would. So anyway, that's all I have for you today. I hope this was helpful for you or somebody you know. Feel free to invite them to listen to this episode and any other episode that I might have released recently. And, follow me. Follow me on social media. Join my group. I have a group on Facebook that's being resurrected. I release a new episode every Wednesday. I have a newsletter that comes out every week. So if you or someone you know is pro se or is considering going pro se, feel free to send them my way. That's my specialty. Until next time, thank you. Take care. Bye.
If you're having an active family court case and something already feels off, you need to identify where your case is seriously exposed. Schedule a strategy session now so we can shield your case from more damage. You can't afford to keep guessing. It's costing you way too much.